Greetings, my fellow Americans. Welcome back to video number 6. Time to continue on our journey, our law journey. Let's see, where are we at today? Well, a few things I would like to talk about. One being the summons. I have 3 parties served. The most important party has been served, and that's the corporation itself. Then there's the fourth party. The fourth party is dodging bullets. So I had to do some research and find out what to do about that. And in the state of Illinois, can't remember if it was Rule 201, something like that. No, Rule 201 is discovery. I can't remember which rule it was, but you file after you do a summons, and the summons was attempted, the sheriff cannot serve or that summons that you sent in. So there has to be another summons. It's called an alias summons, and you go ahead and do that again. This person can't hide, and I wish you could see this because you can't hide. You can't hide because the address you will give in your business card indicates that's where you receive mail and whatever else. It's your business address. It's clear. It is very clear where you are because you also received the affidavit at that address, and I have emails saying that you have received what I have sent you to that address, as well as that signature in that email address says the address that is on the business card and that I had sent the summons to. So there's so many things lining up to say that that's your address. So for you to dodge that, that's gonna look bad on you. Just continue doing what you're doing, and I'll continue doing what I'm doing, and it's all gonna pay off. I am still studying, still preparing. I have a few things that I thought would be really nice to read today, other than talking about the summons and all that good stuff. We're moving on to, Federal Rules of Civil Procedure, which, if I'm not mistaken, talked a little bit about last time. Yeah, Federal Rules of Civil Procedure. We're going to go more into depth with Federal Rules of Civil Procedure, and we're going to see how they so we got Illinois versus Federal Rules, Civil Procedure, and Evidence. Okay, so scope of discovery, we got the Federal Rules of Civil Procedure, Federal Rules of Evidence, FRCP 26B1 versus the Illinois Rules Supreme Court 201B1. Both allow discovery of anything relevant to the subject matter, not just admissible evidence. So, yeah, that's how they both line up. Basically, when the states created their own rules, their own uniform commercial codes, they don't call it a uniform commercial code, but it lines up with the uniform commercial code. They even created their own constitution that lines up with the United States Constitution. Sorry, I yawned a couple times. I'm exhausted right now. It's a little after 5 a.m. I'm still waking up, but I need to do this. It's been a couple of days since I made a video, and I want to keep going over this, and not just I got a lot of schoolwork I'm doing and other things. Of course, I've already made that clear, but I need to continue doing this, and this is really beneficial. This has been very, very beneficial for me. I got this really cool. I'm going off topic, but I have something really cool I want to read here very soon. It's really cold. It is so basically what I'm expecting is a motion to dismiss, which that's okay. When they file the motion to dismiss, we'll go and have a hearing, and I'll lay out the duty breach and damages, why we shouldn't have. I'm so sorry. Why we shouldn't have the motion to dismiss. And that's going to be a very good one because I'll read all that, and I'll read something else about the irrelevance of my trust, because this company tries to make me tell them if I have a trust or not, which is highly irrelevant and illegal. You can't ask people if they have a trust. You can't make people force over information about their trust. It has nothing to do with the situation at hand. Rent or renters agreements, whatever. Okay, anyways, let's move on to meet and confer. Federal Rules of Civil Procedure 26F, 37A1, and Illinois Supreme Court Rule 201K. Illinois requires certification of attempt to resolve disputes before a motion. So, before filing a motion, there has to be a meet and confer. And you have to show that you at least attempted it or tried to, so send something certified. Send receive in the mail, you send an affidavit, you send something. And I don't know if you can do emails or not. I know that for example, I know if my alias summons doesn't go through, I'm going to file a motion for an alternative way to serve her. One of the ways may be an email. The other way I would more prefer is a certified send receive, and we'll go from there. We'll see what the judge allows. So, on from meet and confer, we have interrogatories, Federal Rules of Civil Procedure 33, and Illinois Supreme Court Rule 213. Illinois uses pattern interrogatories plus case-specific ones must be answered under oath. Again, everything's under oath. Document request, Federal Rules of Civil Procedure 34, Illinois Supreme Court Rule 214. Both allow requests for documents, tangible and tangible items. I don't know what is ESI. I can't remember. I have ESI in here. I don't remember what that one was. I should not have abbreviated that. That's okay. Depositions, Federal Rules of Civil Procedure 30 to 32, Illinois Supreme Court Rule 206-212, procedures nearly identical. Illinois has its own timing rules, and that is true. Everything happens at a specific time. My summons, when I served the first summons, they had 30 days. That 30 days started over after I did the alias summons, so now she's got 30 days to respond, or we'll see what happens. I just mailed that yesterday. Request for admission, Federal Rules of Civil Procedure 36, Illinois Supreme Court Rule 216. Illinois is stricter, so silence equals admission. So basically, yeah. Silence means truth in the court of law. That means I win. So, sanctions for discovery abuse. Federal Rules of Civil Procedure 37 aligns with Illinois Supreme Court Rule 219. Both allow sanctions, including default judgment or striking pleadings. Okay? That's sanctions for discovery abuse. So you don't. And basically, in discovery as well, you file a motion to compel if they don't compel. So, carrying on, relevance, Federal Rules of Evidence 401 to 403, and Illinois Rules of Evidence 401 to 403. Identical language must be relevant, not unfairly prejudicial. Okay? So then we go to character evidence, Federal Rules of Evidence 404, Illinois Rules of Evidence 404. So very similar there, actually. Nearly identical, no bad character, proof to show conduct. And then we go on the personal knowledge, Federal Rules of Evidence 602, Illinois Rules of Evidence 602. Same rule, witnesses must have first-hand knowledge. Okay, lay opinion, FRE, which is Federal Rules of Evidence 701, Illinois Rules of Evidence 701. Same again, opinions limited to perception, not expert testimony. And every state, like I said, every state's going to be a little different. Every state's going to have their own code system. Ugh, boy, I'm tired. I gotta start moving my body. I gotta start working out because I started doing this before I started working out to get this out of the way. Anyways, topic here we have experts, Federal Rules of Evidence 702, and then we have Illinois Rules of Evidence 702. The key difference here is that Illinois uses Frye's standards, not Dubart, must be generally accepted in the field. I have to be honest with you, I have no idea what that means. I gotta look more into that. I wrote down these things, and I knew that as I was reading them, I was gonna have to study deeper into them, which obviously I do, but it's good point. Well, so I'll come back with another video next time, video 7, and we'll go deeper into some of these things like where was it? ESI, and then whatever, use Frye standard and not Dubart. No clue. Okay, hearsay, Federal Rules of Evidence 801 to 802, Illinois Rules of Evidence 801 to 802, definitions of exceptions, Rule 803, 804, same definitions. That's kind of vague. I need to go back and edit these. Now that I really read over these out loud, it's a lot different when you put stuff on paper and then you read it out loud. What did I write here? Or sometimes you just didn't explain it more in depth when you should. You remember it at the time, but after you write it, so many other things happen. Anyways, authentication, Federal Rules of Evidence 901, Illinois Rules of Evidence 901, identical. These two are identical. Requirement, proof the item is what it claims to be. And then we have best evidence, Federal Rules of Evidence 1002, and then we have Illinois Rules of Evidence 1002. So as we see, they lined up a lot here. The same rules again. A lot of the codes actually lined up when it came to Federal Rules of Evidence and the Illinois Supreme Court Rules of Evidence. That's pretty cool, actually. Same rule, original required unless exception. So, original evidence. And that's again, like I said, if you try to go in with a buyer's agreement or negotiation, provide the original instrument. Typically, they can't do so because it's been destroyed. Alright, that's all for that one. We can move on to Illinois Procedure and Evidence Rules versus Federal Counterparts. Maybe this will go more into depth. Yeah, it does. Yeah, this one definitely does. So we have Discovery Rules, Scope of Discovery, Illinois Rule 201B1. You must discover any matter relevant to the subject matter in the case as long as it's not privileged, even if the evidence itself wouldn't be admissible at trial. It can still be discovered if it might lead to admissible evidence. So when you get in there, you put that light on them and you dig. You dig. Be prepared, ask your questions, have your questions ready, have what you're going to talk about in front of you. Federal Rules of Civil Procedure 26B1, same idea, discovery of relevant, non-privileged information proportion to the needs of the case. So basically, in plain English, if it could help prove or disprove something important, you can ask for it. So that, I mean, I'm going to go and I'm asking for emails, I'm asking for text messages, I'm asking for, I want to see other lease violations that also have caused or false harm, violations of the First Amendments, a violation of the Ninth Amendment. I want to go over all of this. I want all of this stuff. So we got meet and confer requirements, Illinois 220 or Illinois Rule 201K. Before filing any motion to compel, you must show you tried to, in good faith, to work it out with the other side. So yeah, I have to file I don't know, maybe an affidavit. I have to look more into that. Before filing any motion to compel, you must show you tried in good faith to work it out with the other side. Basically, that's what I can do with the emails and all that good stuff, because I reached out to the area manager and I tried for 90 days, I think it was. I sent emails back and forth. We had a phone interview for 28 minutes and all this good stuff from a certain period to a certain period. And then I had to show that I tried to have discovery with them. I tried to have a meet and confer. Federal Rules of Civil Procedure 26F 37A1. Federal courts also require parties to confer before discovery fights. So basically, you must at least try to solve disputes before dragging the judge in. That's something the judge really wants, because the judge is busy. I don't care how people feel about judges. Their lives are busy. All they're doing is reading briefs and cases. They're busy, extremely busy, dealing with a lot of stuff. And so the less time that you can waste when it comes to the judge's time, less time you waste for him or her, then the better off it's going to be for you, because they're going to see that you're working, you're doing your part, you're doing work for them. You're not pushing them to work as hard as they usually have to, and they're gonna enjoy that a lot. I know that for a fact. Anybody would like that for a fact. If you was working for somebody and you was doing an exceptional job and then a little extra, and it made your boss's life hard or easier, wouldn't that be good? I think so. Interrogatories, Illinois Rule 213, written questions. The other side must answer under oath. Illinois also provides pattern interrogatory standard questions by case type. Federal Rules of Civil Procedure 33, same structure, no pattern sets. Basically, written question and answers, sworn like testimony, requests for production documents. There's that ESI tangibles again. Okay, so Illinois Rule 214, you can demand documents, electronic data, and physical items. The other side must either produce them or explain why not. Federal Rules of Civil Procedure is nearly identical to that one, so both the state and the federal law says the same thing. If it's written records or stored, you can ask for it. So again, emails and text messages and other lease violations, pull this into as I would love to pull this into a class action lawsuit and pull other veterans into this, but they have to be willing to do so. I'll see what I can make happen though. So depositions, Illinois Rule 206 to 212, oral questioning under oath recorded by a court reporter. Notice must be given to all parties. So we have Federal Rules of Civil Procedure 30 to 32. It's the same exact procedure. And so basically what this means is that live testimony before trial, locked in for later use. On to 6, request for admission. Illinois Rule 216, you can serve request that the other side admit certain facts. If they don't respond in 28 days, those facts are considered admitted. Truth in law. Federal Rules of Civil Procedure 36. They're very similar, but actually Illinois is stricter, which makes a lot of sense. Illinois is really strict on a lot of things, but this is good that they're strict on this, because silence equals admission. It's a powerful tool, and if one is silent, well, you won. Okay. Sanctions for discovery, abuse. Illinois Rule 219. Courts may sanction parties for failing to obey discovery, from fines to striking pleadings or default judgment. So the Federal Rules of Civil Procedure, same authority. If they play games, they can lose the case outright. So let's play ball. We're in court for a reason. We're on the court. Do you ever think about that? You got the basketball court, you got and then you got court itself. It's just, you're on the court. Tennis court, basketball court. I don't know what other courts there are, but you get what I'm saying. Evidence rules, relevance rules, Illinois rules 401 to 403. Evidence must be relevant, tends to make something more or less true. It can still be excluded if it causes unfair prejudice, confusion, or waste of time. Federal Rules of Civil Procedure 401 to 403 is highly identical to what the Illinois Rules of Evidence says. Only what matters to the case, no distractions. That's basically what we're looking for. And then we have personal knowledge, Illinois Rule 602. A witness can only testify about things they personally saw, heard, or experienced. So then we have Federal Rules of Evidence has the same exact thing. No guessing or repeating rumors. So keep it logical, not emotional. Emotional intelligence is what they're looking for. Illinois Rule 701, a non-expert can give opinions if based on their own perception and not technical knowledge. Federal Rules of Evidence is the same thing. It looked fast is okay. The speedometer said 85 miles an hour requires foundation. So that's I don't know if you understand that or not. It looked fast is okay. The speedometer said 85 miles per hour and requires foundation. Like, how can you prove that the speedometer was 85 miles an hour? Same thing to a cop. Like, how can you prove that speedometer was 85 miles an hour? Are you saying you shot your radar at me? You know what comes out of that radar? You're saying you shot me. You shot me with, that's electrons that's radiation that's coming out of that gun. And we could go into depth with this. It's not that this is expert knowledge that I'm giving you. This is knowledge that anybody can look up. You can look up exactly what comes out of a radar gun. The same thing when it comes to a thermometer. You can look and see. You can see the radiation that comes out of that. So you're saying you shot me, and with your radar gun, and I was going 85 miles an hour. Well, do you have a picture of that? Do you have proof of that? Probably not. But anyways, expert testimony. Illinois Rule 702, Fry. Here we go. Experts must use principles generally accepted in their field. Illinois follows the Fry standard. Federal Rules of Evidence 702, the DuPont. Federal courts use flexible tests, DuPont, focusing on reliable and scientific validity. So in plain English here, Illinois must be mainstream science. Federal equals broader discretion. Fascinating. Hearsay, Illinois Rule 801, 802, and like I said, expert testimony. We're going to go back over that because that's interesting. I need to know more about that. Hearsay, an Illinois Rule, Federal Rule or Illinois Rules of Evidence 801 to 802. Out of court statements offered for the truth of the matter are generally not allowed. Federal Rules of Evidence, same with many exceptions, Rule 803 to 804. So basically you can't repeat what someone else said unless an exception applies. Fascinating. Authentication. Illinois Rules of Evidence evidence must be shown. Well, this is Rule 901. Better say that. Rule 901. Evidence must be shown to be what it claims to be. Signed affidavits, certified mail receipt, emails, and so forth. Prove the evidence is real. Federal Rules of Evidence 901 is the same language, same lingo. Best evidence rule. The original writing, recording, or photo must be provided unless a valid exception applies. That's Illinois Rule 1002. Federal Rules of Evidence 1002 is the same thing. Bring originals, not copies, unless you have a good reason. Okay? Alright, I think that's all I'm going to read today. I'm exhausted, and I need to work out and wake myself up, get this blood flowing. We will carry on tomorrow when we'll talk about the Illinois Supreme Court Rules of Civil Procedure 201 to 219 versus Federal Rules of Civil Procedure. Anything with the Supreme Court is highly tangible and very good to use. I mean, when it comes to precedent, yeah. You want to find case law that's from the Supreme Court. You want to read that case law, understand that case law thoroughly, and you don't want the judge to question you about certain merits of the case itself, and you not be able to distinguish up from down and left from right when it comes to these cases. Don't use something you don't know. Anyways, that was a good read. That was a good introduction to all that stuff. And peace. Have a wonderful day. Until next time, I hope you enjoy the videos.